I'm joined by Harry Litman of the Talking Feds podcast and the Talking Feds YouTube channel. Everybody, make sure you subscribe to Talking Feds YouTube. Harry Litman, every single week when we talk about Judge Aileen Cannon, she's either being more corrupt, screwing up even more, or just doing things that you and I have never even seen before. Sometimes I feel like it is a hypothetical given to a third-year law student taking a national security law exam about pick out all the things that are wrong here. And it's also so ambiguous that the law student and the law professor also don't fully know the answers to the question. I mean, what she did this past week, basically issuing a sua sponte order, because it wasn't really an order in response to really anything at all. I mean, Donald Trump did file a motion to dismiss under the Presidential Records Act in the Mar-A-Lago document case, where he rather insanely argues, although I don't want to give him an insanity defense, but before Judge Cannon, she apparently thinks this is brilliant, that by the transmutative process of putting classified and nuclear codes and all of our government records and presidential records in boxes and then shipping it to Mar-a-Lago, that it therefore not only telepathically declassifies the documents, but Trump then says it becomes his personal property and it belongs to him, and there's no way to challenge that at all. Notwithstanding the fact that that makes no sense, notwithstanding the fact that the 11th Circuit previously on a Judge Aileen Cannon case where she tried to assert equitable jurisdiction said Trump has no possessory interest in these records, but nonetheless, that's what Donald Trump is the argument that he's making before Cannon. So Cannon, rather than issuing an order, and the way orders work is you either, grant it or you deny it. She was like, riddle me this. Like she's like a Batman villain, right? Riddle me this. I want you, Jack Smith, and Trump's lawyers, but really you, Jack Smith, consider these two hypothetical scenarios. And I want you to create jury instructions, even though I, Judge Aileen Cannon, have already said there's no way there's actually going to be a trial pretty much in 2024. And I basically said this is 2025. But let's pretend the trial is really going to happen in May. Special counsel Jack Smith, assume two hypothetical scenarios are correct, and please guide the hypothetical jury in these scenarios. Hypothetical scenario number one, under the Presidential Records Act, can a former president basically take these documents on his own? And to what extent can a former president hold on to these documents as presidential records, and knowing that this is a former president? So like she's already creating this other classification of like a former president having certain types of access that like doesn't make the former president just an ordinary citizen. So that's kind of her hypothetical scenario number one. Then she goes, assume hypothetical scenario number two is the case, Special Counsel Jack Smith, where Donald Trump can in fact declare any type of document that he brings with him to his own property as his personal property. Now provide jury instructions, knowing that these two scenarios are the scenarios that the jury finds to be the case. Assume the jury made these factual findings. And I'm thinking to myself, one, I got to talk to Harry Litman about this, but the Espionage Act has been around since 1917. There are fairly model instructions when it comes to this. We don't have to create hypothetical scenarios. They get the instructions on what the Espionage Act says in a criminal case, and then the jury can look at the clearly established case law. There have been many espionage cases in our history. Unfortunately, people engage in these types of crimes. But like this riddle, this like game she wants him to play. And lots of people have been debating. I want to get your take. Like, well, can he appeal this? Can he file some sort of mandamus? Is this a final order? And as I look at it, I'm like, I don't even know what this is. Like, what is this thing that she even put on her docket? Like, you were one of the leaders at the DOJ, so like, you know a lot about this. Like, what is this?
Where to start? So first, to the extent there is some view of the merits that underlies it, and presumably you wouldn't serve it up to the jury unless you were saying his Presidential Records Act defense is valid. Although, as you say, the first one, you're taking what would be a legal judgment by a judge to recognize it and saying, convert it to a jury having defined this basically legal question, and that the government has proved it beyond a reasonable doubt. So completely loading it for Trump. The second one, the jury is somehow to make the legal determination that not only can he do it, but it is for, fact finding, a completely beyond anybody's power to review. Those are the two things she said. So what underlies for the Presidential Records Act is loony and from Mars, because in both instances, it's flagrantly misstatements of the law for 8 reasons, but the 8th, Ben, is what you've just said. Even if this crazy scenarios were true, they say nothing about the case because they say nothing about his ability to disregard the criminal law, even if it were true that he had somehow hocus pocus made this personal. Doesn't matter. And Jack Smith carefully charged it. What he's charged with having is national defense records, personal or not, the national defense records, knowingly not giving them back. So the whole thing is completely bankrupt legally, intellectually. But that's just the beginning, because that's, if she were saying that in some kind of weird colloquy or engaging them in court or making the base of argument, be one thing. The actual form of the order isn't from Mars. It's from the planet Mongo in another solar system. You and I and everyone I've talked to has never seen this kind of method to try to resolve a question as well. Assume a jury instruction about something that makes no fucking sense whatsoever. Excuse me, you nice, genteel listeners of MeidasTouch. But it's worse. It's worse because it's pernicious, because we've now seen the seeds. And this is what really, even if you try hard to indulge and give her the benefit of the doubt and say she's inexperienced and not very competent rather than in the tank for Trump, you have to begin to abandon that hypothesis, because what she's doing, and she did the same thing a few days ago when she said your vagueness argument is I won't grant it now, but you can bring it up again once the jury is impaneled. Same thing. If she gets Jack Smith to play ball a little bit and talk about a possible jury instruction, now, when it comes to a jury's being impaneled, and you're right, that seems like it'll be 2035, but whenever it is, what's the deal? Jeopardy has attached, meaning under the Constitution, if she dismisses, or if a jury completely informed and given faulty law holds for him, or if she just dismisses it based on this for completely illegitimate reasons, once Jeopardy has attached, he cannot be retried. So it looks as if, I think the reason she's doing this, rather than, as you say, what any judge would do, if that's what you believe, put it in an order. A order can be challenged, and this is what really makes it seem like she's in the tank for Trump. She's doing everything she can to avoid giving Jack Smith something he can challenge. Some people have said on TV, a mandamus. But as you say, mandamus for what? What she said is, engage with me in this bizarre hypothetical. What's reversible about that? And she seems to be very purposely, cunningly saying things that are bizarre and augur a great result in either delay or even substance for Trump, but avoiding the oversight of the 11th Circuit and the possibility that she already has 2 strikes against her. We've talked about this before, that it comes up and they then recuse her. I think you're right that there's just nothing for Jack Smith to grab onto. So the third, what makes this really not just bizarre but pernicious, is she's happened on a way of really making trouble, but maybe avoiding appellate oversight. It is just a total total mess.
So here's what my thought was, but I didn't work at the DOJ, or I was nor was I one of the leaders at the DOJ. So I want to hear more of your thoughts. But my
Yeah.
thought basically is Jack Smith's response is to respond and say, look, while we respectfully, understand that a question's been asked, we can't provide an answer to either of those scenarios as they violate clearly established precedent, 11th Circuit law, and therefore, we cannot provide a response. However, pursuant to the model jury instructions under the Espionage Act, we're providing the standard ones that were used. And then you basically cite, to keep it local, any other espionage case in the Southern District of Florida. And then you try to cite 11th Circuit cases that deal with the Espionage Act. You put those there, you see how she responds, and then based on that, you can kind of see where you're at. You don't take the bait here. That's what I would do, but what would you do?
So look, I agree. And in fact, even more, you try to force her to an order. So she gets all upset and chastises him or sanctions him or makes him say it again. At that point, if push comes to shove, maybe there's actually something to take up. But I think that both choices are a little bit precarious, but I'd rather get her angry than play ball in a way that would somehow support a down the road dismissal that couldn't then be challenged. In fact, get her upset, get her to do something to you, then you can appeal that.
Yeah, and that's, when you watch that, you just see someone in Judge Cannon who, frankly, setting aside that she should not be the judge in this case, which is obvious, like this is someone who should not be a judge, period. You agree or disagree?
Yeah, look, it's true. It was at the end. I mean, I would have tried to be open to it, but she's really shown herself to be. What do you want in a judge? Learning, prudence, judgment, impartiality. That's strike 4 on her. And it's just this is all I know about, but she hasn't done very much. She's really been a disgrace, I got to say, in this case.
Well, we'll keep you posted with more updates on that as soon as we hear more. Make sure you all subscribe to the Talking Feds YouTube channel. Just go on YouTube, search Talking Feds. You'll get more takes by Harry Litman and his team there of former feds. Love the channel and check it out. Thanks, everybody, for watching. Hit subscribe here, and we'll see you next time on a Harry and Ben Hot Take.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.